What if accurate information is the essence of a bargain? Now, I know you don't think we need to get into this, and you may be right about that, but I just want to draw on your knowledge of criminal law and your understanding of common law fraud. So take this example. Suppose someone hires an agency, enters into a contract with an agency to find, let's say, a nanny for their children, or a caregiver for an older person. And the agency promises that they're going to do a thorough check of these individuals. They are going to contact prior employers and get references and do a criminal background check. And in fact, they do none of those things. But it turns out that the nanny or the caregiver actually does a decent job. Is there not fraud there?
There may be, Justice Alito, and it would turn on whether the government chooses to show pecuniary loss. Overcharging, overpaying for services that were not performed. That is the kind of conventional fraud case that the government points to in the Finazzo case.
Yeah, but what if there is no, they don't try to prove that they paid too much, but they paid for a person who was unproven.
Yes.
And what they wanted was somebody who was a proven commodity. Well, certainly they're going to think we were defrauded. We were exposed to a risk that we didn't want to undertake, and we paid money for that. That's just why we paid the money. Why isn't that fraud?
So they certainly were deceived. And the government certainly can try to show that there would be pecuniary loss associated with that they paid for services that they didn't get, which is a very conventional type of fraud claim. If all there is deceit and the contract actually was a fair exchange and the employee was fully competent, capable, certified, qualified, then it wouldn't be common law fraud. It might be some other crime that covers deception. It might be a civil case that would entitle the victim to rescission. The civil rules have different criteria and requirements than the criminal law. And it might be a violation of some other criminal statute. But the fraud law at common law always looked to some kind of a loss, be it pecuniary or loss of specific property that you set out to buy, or something else that could be monetized. Because after all, fraud law originated in protecting people's property rights. And this court in McNally said it protected against being wronged in your property rights. And it didn't mean conventional fraudulent inducement, which is grist for the mill in 1,000 civil cases that would all become fit cases for criminal fraud if the government's new and vastly enlarged fraudulent inducement theory is adopted. So while the victim may have a subjective sense of being wronged, that does not mean that it fits within the parameters of what has always been required for a fraud scheme up till the government's current submission, which is some sort of a scheme to deceive someone for the purpose of obtaining property in a way that would produce a pecuniary loss or some other harm to a traditional property interest.